Hi there, I'm Michael Bovee with Consumer Recovery Network. Thanks for tuning in to DebtBytes, our YouTube channel. We talk about a bunch of different topics dealing with debt and credit. Today I want to talk about dealing with a specific collection law firm in California. So if you're in California and you're dealing with Hunt and Henriques because they're collecting a debt for somebody, they're not a debt buyer, they're a debt collection law firm, and they are hired a lot by folks that you may owe, like your credit card bank. Hunt and Henriques, their model for collecting is pretty aggressive in that they use the courts a lot. If they've gotten your file, they've more than likely also received authorization to file a lawsuit to collect from you. And when you're a collection law firm and your business model suggests that all you have to do is, one, either get you to pay or get a judgment, those are their only two goals, is to represent their client to the best of their ability to one of those two ends. And if you file lawsuits and win or get a judgment against you, the debtor, 90 or more % of the time, you don't change much of your business model because it's working really well year after year. What you have to do sometimes when you're dealing with Hunt and Henriques is, I would prefer most folks try to negotiate a lump sum payoff for less than what you owe, because frankly the fact that you're being sued means you've gone without paying your debt long enough to where all the damage is done to your credit report. You're not going to get any brownie points for paying more or the balance of the debt, plus all of the fees that might be added on if the court process has already begun. So negotiating a lower balance payoff is an option. It's a little bit more, I guess, difficult to get Hunt and Henriques to be flexible and reasonable on first contact. It's really hard to do that with most any collection attorney, but Hunt and Henriques, in my experience, working with consumers for the last couple of decades, is just a little bit more difficult to get reasonable results from right when they get the account or right after they file a lawsuit. However, if you file an answer and you defend their claim, sometimes for very legitimate reasons, as in, they shouldn't have been suing you for this or this amount, and you're not sure about any of those things. Those are obviously, things that you have to do. You have to defend yourself. But a lot of the time it's just debt that we know about, we recognize, and we just like to resolve it. Filing an answer is causing you to be the 10%, right? So I talked about 90%, they just put their shoes on and go to work every day and have the same kind of return on their energy. Then they're not going to do anything different, except when you're part of that 10% that they don't just get these easy layup type of judgments by default or summary. So when you defend yourself, they're traditionally going to look at you a little bit differently, and they're going to offer maybe some more flexibility in your settlements. When the fact that you're in California dealing with Hunt and Henriques, and actually they have some offices elsewhere now, they've expanded, but I'll focus mostly on California, but they're up and down the West Coast. So your situation is that your courts are really slammed. LA County, for example, you can file an answer and not have anything to do except negotiate a reasonable outcome with Hunt and Henriques for the next 4 or 5 months. Sometimes you can buy yourself as much as a year's time before, so let's say you got a $10,000 account and you want to try and sell it for 5, which is a realistic, still optimistic, but it's a realistic goal to settle when sued, half. And so you need 5,000, but it's going to take you 6 months to raise that money. You can get that from participating in the court process. You can get help. There are really good, experienced, and even affordable attorneys in California that help consumers resolve collection issues. At the court level, I refer to them often enough on our YouTube channel and on our website as debt collection defense attorneys. And so if you have a situation and you want to get referred to one, post in the comments below, call us and press 2, that rings to me. I can hook you up with some resources in California that can help you if you're fish out of water, like most of us are going to be if we're sued. Having an attorney help you file an answer that's going to survive and give you the time that you need to buy that 6 months in this example is awesome. You want to do it. A couple of things. California is pretty expensive to sue somebody in. So even the debt collectors, when they file those actions, it's a couple $100 or few sometimes. And for you, even to file your answer, there's a cost, a couple $100, right? Unless you can show that you're indigent or meet some kind of exemption for having to file and pay those fees, then you have to expect that. That's going to be part of the cost of dealing with this situation. Hunt and Henriques, when you go to negotiate after you filed an answer, you're typically going to find a little bit more flexibility and or the ability to get to any settlement, whereas you might have hit a brick wall about settling for anything, any savings, prior to filing an answer, or at some stage later on in the process of defending yourself. You'll hit a place where they're going to recognize that, again, part of that 10%, it's better to get what they can. You can bring up the topic, they might bring up the topic, but I typically find it's best for you to approach them. Okay, well, look, I don't have this amount, I have this amount. And in fact, it's not even my amount. It's money I'm borrowing for a family member, friend, or whatever. It's the only reason I have this money, but they're willing to give it to me if this settles the deal and it goes away. Why? Why do you want to do this? Well, being sued costs. When you get a judgment against you, it's all of the legal fees are attached to it. The longer that judgment sits there, California caps interest rates at 10%, judgment interest at 10%. So it's not out of control, certainly, but it does mean that the debt balance is going to grow the longer it sits there. In California, you can be garnished your wages up to a certain amount. You have money in your bank account that's not exempt. Then you can have a bank levy. Go to bed with a certain amount of money in your bank account, wake up and it's gone, right? So there are reasons to avoid the judgment to begin with, and reasons why you have to change the way you deal with your personal finances if Hunt and Henriques already has a judgment against you. So you have to make some changes. You have to adapt to the situation until you can circle back with enough money with a realistic expectation of settling with Hunt and Henriques. Whatever your situation is, you're dealing with Hunt and Henriques, post about it. We can offer feedback in the comments below. Call us. You can personally reach me at option 2 on the hotline on the screen, and I can go over some of the options as I see them once I dig a little bit more into the details of your situation. See you on the next video.